Hello, RWorld, and welcome back to RWorldTalk. I wish that I could tell you guys that I was excited to have this podcast. I am excited to sit here and talk to Miss Courtney Kahn again. She's our first podcast guest that is making a second appearance. I wish that it was under better circumstances. I will let you guys know that this is not going to be a very exciting podcast filled with laughter because we are going over some pretty serious stuff. It is all going to be about the legalities of what just happened with the Sitzer trial. I know that many of you guys have been following over the last couple of weeks, but I certainly do know that a lot of our members and a lot of our brokers have not been following what is going on. So please do share this podcast with them to bring everybody up to speed on exactly what is going on. With that being said, hi, Courtney. Welcome.
Hi, Chris. Thank you for having me here today.
So I'm sure many of our listeners did watch the Sitzer trial. They've been looking at all the media outlets, Inman, Riz Media, trying to find out exactly what has been going on, what is happening. We just had a big decision made. The verdict is out. But we want to make sure that everybody's got the information straight from our mouths and not getting it from opinionated media publications. Mm-hmm. So why don't you tell us how we got here and what this case was all about?
Yes, absolutely. So before I get into that, I do want to preface this discussion to say that this might seem like there's less commentary here today. However, it's because we want to make sure that we are providing our listeners with the facts and just the facts only so that they know they are getting reliable and accurate information. But opinions will be kept out of it for the most part today. So If it seems like there's a little bit less commentary from me, that's why. So I'm here to give you accurate, reliable facts so everyone knows what's going on.
Okay.
So with
floor is yours.
Yes, thank you. With that being said, I will get into some background as to how we got here in the case and the trial that just finished. So as you mentioned, it's the Sitzer case. What happened with that case by way of brief background is it was filed back in 2019 in federal court in Missouri. It is a class action case, which means that the case was being brought by several plaintiffs. So a bunch of plaintiffs grouped together, and they are all home sellers. And so those sellers together are suing NAR and several other large brokerages. So this case has been going on for several years. What happened during those several years was that it went through the normal course of litigation. What typically happens in litigation and what occurred here was that they engaged in what's called discovery. And so each side exchanged documents, they exchanged their evidence, they took depositions. And so all of that occurred. They filed several motions as well, where the court made a lot of different rulings, including motions for summary judgment. Once all of that occurred, they finally were ready for trial, and then the trial occurred.
Okay. So how did the trial work procedurally? What exactly happened over the course of the last 2 weeks?
Yeah, good question. So what happened with this trial was it was actually an 11-day trial. And what happened was it started off with what's called jury selection. And so what happens is jurors are selected to hear this case. So usually start off with a very large pool of jurors, and then it gets whittled down throughout the process of jury selection until you end up with the final number. In this case, it was whittled down to 9 jurors. Okay. One of the jurors actually was excused for personal reasons. So we ended up with 8 final jurors who made the decision on this case.
Okay.
So after jury selection occurred, what happened next is called opening statements. And that is basically an overview that each side will give to the jury to kind of explain on what they can expect to see throughout the trial and just an overview of their case in general. So all of the parties made opening statements to the jurors. After that occurred, we had the plaintiff present their case first, which is typical in jury trials. So the plaintiff went first. They presented their evidence. They had their witnesses testify. They put on their whole case for the jury.
Okay.
After that, we had all of the defendants go, and then the defendants did the same thing, and they all got to put on their case for the jury. So they presented their witnesses, they presented their evidence as well. And once that occurred, we ended up finishing out the case with what's called closing arguments, kind of similar to opening statements. But closing statements come at the end, and it's basically just a summary that every party gets to give to the jury where they explain one last time why they feel the case should go their way and any other final summary that they want to give to the jury.
Okay.
So once all of that happens, what occurs next is jury deliberations, which is what occurred yesterday in this case. Okay. And what happened was the jury gets together and they essentially just deliberate the case and talk about it so they can come to a decision and a conclusion on the outcome. In this situation, the jury actually ended up deliberating for approximately 2.5 hours.
Okay.
Mm-hmm.
Who are the defendants in that case?
Yeah, so I actually have the verdict form here. So all the defendants were listed, and I'm going to read those to you. So from the verdict form, the defendants were the National Association of Realtors, Home Services of America, BHH affiliates, HSF affiliates, Keller Williams, Anywhere, and RE/MAX.
Okay. And what was the outcome?
So the important question on everyone's mind, if you have not seen it yet, is that the outcome was that the defendants were found liable. Now, I do have the verdict form here with me, and I would like to take a moment to read through that.
Go for it.
Because I think that can offer some pretty important information on the case.
Okay.
So there were 5 questions on the form that the jury decided on, and I'm going to go through those one by one. The first was the following question. Number 1, do you find that class plaintiffs have proved by a preponderance of the evidence that a conspiracy existed to follow and enforce the cooperative compensation rule in the subject MLSs during the conspiracy period alleged in this case, April 29th, 2015 through June 30th, 2022. The jury marked yes. And I will just note as a side point that the reason that 2015 is in there is because the antitrust laws have a 4-year statute of limitations. Okay. And so this case was filed back in 2019. And so 4 years prior to that would bring it to 2015.
Gotcha.
So that's why you see 2015 in the
Understood.
verdict form.
Thank you for that explanation.
Yes. So moving on to the second question on the form, it says, do you find that the conspiracy set forth in question 1 had the purpose or effect of raising, inflating, or stabilizing broker commission rates paid by home sellers? The jury answered yes.
Okay.
So moving on to number 3, the question is, which of the following corporations or entities do you find knowingly and voluntarily joined the conspiracy set forth in question 1 with the purpose of furthering its goals? All of the defendants are listed, and yes is marked for all of them.
Okay.
Moving on to the 4th question. Do you find that the conspiracy set forth in question 1 caused the class plaintiffs to pay more for real estate brokerage services when selling their homes than they would have paid absent that conspiracy? The jury selected yes.
Okay.
Now last, the final question is 5, which pertains to damages. It says, state the amount of damages proved by the class plaintiffs. The jury wrote $1.785 billion.
Billion.
Yes,
with
billion.
A B.
Yes.
Not an M.
Yes.
Okay.
Billion. I will note as well that in antitrust cases, there is what's called treble damages. And that is essentially where in certain cases, like in antitrust situations, the law allows the damages to be tripled. And in this case, the damages are being tripled. So that would bring it to approximately $5.5 billion after the treble damages are imposed.
That is a lot of money.
Yes.
Okay.
Yes.
Well, see, guys, I told you this was going to be a little dry, but my goodness, is that some eye-opening stuff.
An important topic nonetheless.
Important topic. So let me ask you this question. $1.78 billion. Is this a number that those 8 people arbitrarily in a room pulled out of a hat and put down on that form? Or is there a calculation for that amount?
So that's a great question, Chris. So what happened was each side had experts testify as to the damages and the amount that they were alleging that was caused by the harm on the plaintiff's side.
Okay.
So they actually had witnesses testify to the monetary damages that were imposed, and that's how they got to that number, through their experts and through their witnesses who testified about the calculation of how to get to that number.
Gotcha. Okay. Thank you.
Yeah, I will add as well, too, that you'll often see in class action cases that the damages are usually a large amount and greater than other sorts of cases because there are so many plaintiffs, right? A class action is being brought on behalf of several plaintiffs. So because you have more parties involved, you do see more monetary damages.
Gotcha. Okay. So it's not just one person named Sitzer that decided that they were just going to go after NAR and some other people there. Okay. So next steps, I assume, which I know you hate assumptions when you're talking about legal things, but
it's true.
Let's just say, I'll ask you the question just very straightforward. Is NAR going to appeal this?
Mm-hmm. So NAR actually sent out a communication yesterday, which stated that they do intend to appeal the liability finding. They also noted that due to the nature of appeals, the appeal could take several years to conclude. As we've seen throughout this litigation process, it is certainly not super quick by any means. Litigation in general can take several years to conclude, so that's not totally surprising.
Yeah, we just witnessed it because, like you said, this was filed in 2019, and here we are in October of 2023, and this case was just heard.
Yes.
Over the last couple of weeks. So, okay, is there any scenario where NAR would be settling in this case?
Yes, another good question. So I'll read to you what NAR wrote. And so NAR has stated that they, and I quote, always has been open to a resolution that maintains a way for buyers and sellers to continue to benefit from the cooperation of real estate professionals and eliminates our members' risk of liability for the claims alleged. That being said, we remain confident we will prevail on our appeal. I do want to point out, and I think this is an important point, that they can possibly settle after a verdict came in. I think sometimes people don't realize that you can settle. Even after a trial starts, you can settle during a trial. You can even settle after a verdict comes in. So it is permitted to settle at that point as well.
Okay. Any important takeaways from the trial that you want to give our membership?
Yeah, so I would say I have 2 main takeaways that I would like to share. The first, you've probably heard me say this before, but I will say it again, and I will probably keep saying this till the day I die. But that is to be cognizant of social media and the communications that you're putting out, especially in writing.
Absolutely.
Something that we saw in this trial particularly is that social media and written communications were used, and they were used against the defendants. And so it's important to keep in mind that what you're putting out there into the world, especially in writing, it can be used against you. It can be used at a trial, especially to your detriment in a lot of situations.
Right.
So being cognizant of what you're putting out there always and making sure you're staying on the safe side is so, so important.
Yeah, and there are people that are engaging in a lot of banter on social media in the last few days because of the outcome of this case. It's very important for people to be super protective of what they are putting out there into the world because we've talked about this on the podcast before. You put it out there and you think that you could take it back, but it's like trying to put toothpaste back in the toothpaste tube. It's impossible to do.
Yes.
So people need to be very careful. And right now is a great time for us to continue telling that story of our value and what we provide the community as realtors and advocates for homeowners. Now is not the time to be throwing yourself out there on social media and engaging in a lot of the misinformation that is surrounding this trial and what has happened, which is why we thought it was really important for Courtney to come on and give you guys the straight facts without the opinions, without the banter. So that way you know exactly what's happening in the industry and how best to move forward and serve our homeowners.
Definitely.
Obviously, it was this week has been very historic in the real estate landscape.
Yes, and the other takeaway that I do want to mention is that it's imperative for members to continue to express that commissions are negotiable and they are set between brokers and their clients. It has always been like that, and it's important to remember that.
Yeah, it's always been like that. It always will be like that. Certainly, commissions. We negotiate every day. We negotiate with our home sellers when we're listing their properties. We negotiate. We negotiate every piece of that contract. We're great at doing it, so let's continue that practice.
Yes.
Okay. Anything else that you'd like to add for us today?
That's it. Just remember those tips, and I think that will go a long way, especially the social media aspect.
Okay. Short and sweet there for you guys. We will see you right back here next time on RWorldTalk. Thank you so much, Courtney.
Thank you for having me.
All right, guys. See you later.